today's presentation, I, William, Chilam, Vicky, Ada are going to discuss the case of Jiangsu Beier Declaration versus Angel World. So we further divided our presentation into 4 parts. The first part is the case outline. In this part, I will deliver you the background information of the case and help you get a general picture of the case. The second part is the case introduction. In this part, William and Chilam will help us get more familiar with the whole case. And that part is the analysis of the case. In this part, by discussing the main issues of the case, Vicky and Ada will help us get a deeper understanding of the whole case and some relevant articles. And the final part is the implications and conclusions. Now let's begin. So in the case outline, there are 2 companies in this case. Jiangsu Beier Declaration, which is based in Jiangsu, China, is majoring in manufacturing and selling wood flooring. Angel World, which is located in Philadelphia, US, is a furniture and home finishing merchant wholesalers. So, on the May 20th, 2016, they signed a US regional exclusive agency agreement. Under the agreement, Angel World shall act as the sole agent of Jiangsu Beier Declaration, soliciting orders for products of Beier Declaration in the specific regions and purchasing products from Beier Declaration. Well, things have been run quite well until 2018, maybe because of the decline of the market. So the 2 companies had some arguments on the payment issue. So they further signed a memorandum of understanding to settle down the payment issues. So the memorandum confirms that of the total payment of nearly $1,400,000, $1,078,314, further reducing the discount of $270,000 to $528,277 was the undisputed part and should be paid by Angel World by installment. The payment schedule was also given here. So as you can see, there are totally 6 months of paying period. Angel World should pay $87,000 each. So if the Angel World cannot make payment on time, then there's no discount. And for every day overdue, the Angel World should pay 0.05% of the amount overdue. So the Angel World made the first payment and a late second payment, and then refused to make further payment, despite the Jiangsu Beier Declaration kept on sending emails requesting for that. That's why they went to the court. So at first glance, the case seemed to be simple and quite straightforward. But by reading the documents, we find something more tricky. More than one memorandum appear in the case in a stage of offer and counter-offer. On July 11th, the Jiangsu Beier Declaration sent the July 10th memorandum version 1 to Angel World. But strangely, the date of sign is June 28th, 2018. And thus the memorandum was referred to as June 28th memorandum. Also, on July 19th, 2018, the July 10th memorandum version 2 was sent. The signing date is July 10th, 2018, and thus refers to as July 10th memorandum. But the contents of this memorandum varies too. For example, in the June 28th memorandum, the Angel is required to pay Jiangsu Beier Declaration within 6 months after signing the memorandum, while in the July 10th memorandum, the Angel World should pay Jiangsu Beier Declaration before January 31st of next year. So each version of the memorandum was actually independent of the other and should be regarded as a new offer. So here comes one of the main issues of the case, which is which one of the 2 memorandum is binding on both parties? Is the July 10th memo or the June 28th memo? And second, as the validity of the memorandum is doubtful. So here comes the second issues. Did Andrew Will's refused payment constitute a breach of the memorandum? Well, the main issues will be handled by Vicky and Ada. Now it's time for William and Chilam. Let's welcome.
Next, me and William are going to introduce the case to you briefly. On May the 20th, 2016, the applicant and the respondent signed the U.S. Regional Exclusive Agency Agreement, hereinafter referred to as the Agency Agreement. This agreement provides that the respondents act as the sole agents of the applicant to solicit orders. Subsequently, the respondents successfully placed orders to purchase the products to the applicant's order-taking company in accordance with the agency agreement. On July 10, 2018, the applicant and the respondents signed a memorandum of understanding, hereinafter referred to as the July 10th Memorandum, on the settlement of the payments for the trade transactions between the two parties. The main articles of the July 10th Memorandum are as follows. First, both parties confirm that the undisputed part of the purchase price totaling $1 million, hereinafter referred to as the undisputed payments. Second, from the above undisputed payments, $280,000 is temporarily deducted for the applicants to calculate the actual payment amount of the goods based on the actual quantity of products returned. Thirdly, about $300,000 of the purchase price unilaterally claimed by the applicant should be paid off within 6 months upon final verification by both parties. Lastly, the applicant agrees to give the respondents a certain discount amount, $270,000 for the undisputed payment. The respondent shall pay the applicants the equivalent of the undisputed payment minus the reserve payment and deduct the discounts from it according to the payment schedule agreed in the July 10th Memorandum in the amount of $500,000. But at the same time, it is agreed that if the respondent fails to make the payments in accordance with the schedule agreed in the July 10th Memorandum, the discount amount will no longer be valid, and the respondent shall pay the applicant $798,000. If the respondent pays behind schedule for every 1 day overdue, it should pay the applicant a liquidated damage of 0.05% of the overdue payment. In October 2018, after having made the first and the second payment, the respondent stopped subsequent payments. Although the applicants repeatedly urged the respondents to make the subsequent payments, the respondents refused to make any payments. Based on the above facts, the applicants filed the following arbitration requests in order to protect its own legitimate rights and interests. Firstly, they requested a ruling that the respondent shall pay to the applicants all of the outstanding amounts for the goods totaling $1.2 million. Secondly, request a ruling that the respondent should pay the applicants a penalty of $71,000 for overdue payments. That is 0.05% of the overdue payments. Third, request for an award for the arbitration fees, the certification fees, appraisal fees, translation fees, and so on. And lastly, the respondent shall bear the legal fees of 734 renminbi for this case. Next, William are going to introduce you to the respondent's primary response.
In response to the applicant's request, the respondent made following arguments. Firstly, this case should be limited to the effect of the arbitration agreement, and contract disputes do not fall within the scope of this procedure. The ruling on the July 10th Memorandum and other main contract disputes is not binding on the arbitration proceeding. The arbitration tribunal shall independently hear the case in accordance with the arbitration rules regarding jurisdiction and entity disputes. Secondly, The jurisdiction of the arbitrational tribunal over this case is limited to the July the 10th memorandum itself, containing the arbitration clause. However, the respondent did not sign the July the 10th memorandum with the applicant. Therefore, the applicant's arbitration request based on the July the 10th memorandum should not be accepted. Third, the applicant's arbitration request and the scope of dispute actually exceed the scope of the July the 10th memorandum, as they involve the agency agreement and the international sales of goods. So the arbitration commission has no jurisdiction. There is a jurisdictional conflict in this case, and it is also probable that a U.S. court will refuse to recognize and enforce this arbitral award, as it does not comply with the New York Convention. And then Chilam will show you the applicant's main counsel arguments.
Here comes the applicant's main counsel argument. The first argument is that the July the 10th memorandum was duly established and entered into force. The arbitration commission has jurisdiction over this case. The main reasons are as follows. In Beijing, the Fourth Intermediate People's Court has determined that the July the 10th memorandum is a contract that has already taken effect, and its arbitration clause is also valid. Then, the June the 28th memorandum was only a negotiation draft and did not take effect. After the June 28th memorandum, the two parties reached the July the 10th memorandum after several rounds of talks, and the respondents actually fulfilled the July the 10th memorandum. So it was established and effective. After the respondents refused to perform its payments of obligation, the applicant also made the payment demands to the respondents in accordance with the July the 10th memorandum. Secondly, the July the 10th memorandum has been established and entered into force. The respondents shall make all outstanding payments totaling $1.2 million in accordance with the July the 10th memorandum, and pay corresponding liquidated damages, attorney fees, and bear the arbitration costs of this case. Lastly, the product quality issues mentioned by the respondents during the hearing of this case are not within the scope of the hearing, and the respondents has not provided valid evidence of the product quality issues to the applicants. So turning to the respondents' main counsel arguments, let's shift to William.
The respondents' main counsel opinions are as follows. First, the June the 28th memorandum signed by the respondent and the applicant has come into effect and has been implemented with binding force on both parties. Secondly, the June the 28th memorandum was stamped by the applicant and signed by Wang Beier, the representative of the respondent. Although Article 6 of the June the 28th memorandum stipulates that this agreement shall become effective after being sealed by both parties, whether the respondent recognize Wang Beier's act of signing the agreement on behalf of the respondent and the validity of his signature are open to interpretation and ratification by the respondent. The power to interpret the validity of Wang Beier's signature rests with the respondent, not with the applicant. Thirdly, the applicant's flip-flop is unreasonable. The applicant's actual signing of the June the 28th memorandum and the actual receipt of the payment from the respondent, as well as the act of hiring the debt collection company to pursue the performance of the June the 28th memorandum in December the 2018, prove that the applicant had no doubt about the June the 28th memorandum. Its claim in this case is a flip-flop on the June the 28th memorandum, which lacks legal basis. Fourth, there are three versions of the July the 10th memorandum. and the applicant's statement about the date of the execution of the agreement, the method of signing, and how it reached agreement with the respondent to sign the agreement are all contradictory with the existing evidence. So the applicant is unable to prove which version or versions of the July the 10th memorandum were signed with the respondent, and which version of the July the 10th memorandum is binding with the respondent on both sides, on both parties. That is the basis for its claim for payment of goods. Moreover, the applicant and the respondent did not reach any agreement to sign any version of the July the 10th memorandum, nor did they sign any relevant agreements. Next, Vicky will introduce the case analysis.
So, judging from the previous introduction part, it is clear. So, judging from the previous introduction part, it is clear that the actual dispute between the two parties in this case is resolving the issue of payment for goods. More specifically, the two different memorandums, one from June 28th and other from July 10th, stand at the focal point. And here comes to the analysis part, which will be delivered by me and Ada. Before we start, I would like to introduce the framework of our analysis. The first part of our analysis will focus on the application law of the July 10 memorandum. Then we'll shed light on the effect of July 10 memorandum according to CISG. In the third part, we will continue to talk about the respondent's breach of the contract and relief, while in the fourth part, we focus on the ruling. Now, let's move on to the first part about the application of law on July 10 memorandum. In this case, since both parties have their business operations in China and US, which are the parties to United Nations Convention on the International Sales of Goods. Therefore, according to Article 1 of CISG, the July 10th memorandum shall apply the CISG provision. At the same time, considering that the legal agreement was reached in China, the basis of the creditor's rights and debts relationship started in China. The main agreement negotiation was mainly conducted in China. The place of arbitration is located in China. We know that the July 10th memorandum has the closest connection with China. Consequently, any issues within the scope that CISG has not clearly resolved shall be resolved in accordance with Chinese laws. Then, we move on to the second part about the effect of July 10 memorandum. We will begin with the determination from Beijing the 4th Intermediate People's Court and Arbitration Tribunal. As we can see, both of them regard the July 10 memorandum as a valid contract. More importantly, we try to expand on the validity of the July 10 memorandum based on CISG as follows. First, we reckon that the June 28 memorandum is ineffective and was just a draft for negotiation because of the inconformity with the general practice of contract signing. More specifically, for one thing, Wang Biao, representative of correspondent's signature on the June 28 memorandum, was not a substantive endorsement of the signature, as he signed the June 28 memorandum on the same, which does not conform to the general practice of contract signing. For another thing, actually, Wang Biao did not have the power to sign the June 28 memorandum, which needed to be signed by Jason, the legal representative of the respondent. Another reason for the ineffectiveness of June 28 memorandum is that the respondent did not agree with the relevant contents of it. In fact, the respondent didn't pay the money the following day in accordance with the June 28 memorandum. and the respondent's financial staff sent an email to the applicant's employees on July 3rd, 2018, and adjust the first payment time and amount under the June 28 memorandum. The third but most important reason why the June 28 memorandum is ineffective is that the acceptance of it doesn't take into effect, which means that the parties had not reached a binding contract. According to CISG Article 18.2, the acceptance of the offer takes effect when the notice of the consent is delivered to the offerer. In this case, the applicant failed to stamp the June 28 memorandum and return it to the respondent, which means that his so-called acceptance of the offer did not take effect. Therefore, the June 28 memorandum was not being reached, nor it is a binding on both parties. Now, we continue to analyze the case and give explanation about the effectiveness of the July 10 memorandum. First, July 10 memorandum is a new offer born of June 28 memorandum. It is the fact that the revised draft of the memorandum added contents such as liability for the breach of the contract and dispute resolution clauses on the basis of June 28 memorandum. According to the provisions of CISG Article 19, the applicant's action was a refusal and counteroffer of the new offer of the June 28 memorandum, and the subsequent changes in the payment amount and the time of the respondent. Therefore, it is reasonable July 10 memorandum shows the date of June 28, 2018. Secondly, actually the July 10 memorandum is binding on both parties, as the applicant sent the respondent final draft of July 10 memorandum, and the respondent made 2 payments to the applicant. And CISG Article 18.3, the respondent indicated the applicant that it agreed to the final draft of the July 10 memorandum by its act of making payments thereunder. The third part of our analysis will focus on the respondent's breach of contract and relief. To begin with, according to Article 15.3 of CISG, the buyer must pay the price of the goods and take delivery of the goods in accordance with the contract and convention. In this case, since the applicant claims that the respondent should make all the outstanding payments, he shall have the right to require the respondent to pay the purchase price confirmed in July 10 memorandum. In addition, according to CISG Article 25, a breach of the contract committed by one party is fundamental if they result in such detriment to the other party as substantially deprive him of what he is entitled to expect under the contract, unless the party in breach did not foresee, and a reasonable person of the same kind in the same circumstances would not have foreseen such a result. In this case, the applicant claims that the respondent should pay the penalty for the overdue payment at 0.05% per day until the actual payment day, which is based on the respondent's breach of the contract. Therefore, it should be paid in accordance with July 10 memorandum agreement. The fourth part of our analysis is about ruling, which will be delivered by Ada.
The Article 2 and Article 3 of the legal service contract shed a light on the attorney fees and other fees, which are based on the Chinese laws. And finally, the arbitration tribunal makes the following rulings. The response shall pay 623,227.59 for the goods to the applicants, and the liquidated damage for overdue payment from September 29, 2018 to the date when the payment is actually paid. At the same time, the response should reimburse the applicant with the lawyer fees, which is 380,000 yuan. What is worth mentioning is that the payment should be paid to the applicant within 30 days. As for the arbitration fees, the applicant and response will bear it together. The fees are 109,954 yuan and 80,443 respectively, except from the fees mentioned above. The arbitration tribunals rejects other requests of applicant. So here's our analysis of this case. Now let's welcome Peter to illustrate of what we learned from this case.
Okay, so here comes the implication conclusion. So in today's presentation, we have delivered you the outline, introduction, and the case analysis. So this case has wanted us to pay attention to the process of offer and counter offer. The offer and counter offer process are especially tricky when it comes to differentiate concepts like acceptance and rejections. There is a need for us to review the relevant articles in CISG. Also, the importance of communication in today's business is emphasized in this case. The happening of the case was largely attributed to the poor communication between the two parties. And also, we suggest Jiangsu Beier Declaration to check the financial report of its counterparty future, if possible. That's the end of our presentation today. Thank you for listening.